Whether for personal, business, or investment reasons, many people desire to purchase property with another person or partner. A joint purchase is particularly desirable where sharing the financial burdens associated with property ownership allows the parties to purchase a property that would otherwise have been out of their financial reach. It can also serve as a valuable estate planning tool. Before deciding to purchase or hold property with someone else, however, it is important to understand the different types of property ownership available. Three main methods of co-ownership are available under the law: tenancy in common, joint tenancy, and tenancy by the entirety. Tenancy in common is the type of co-ownership of property most commonly understood when real estate is owned with a non-spouse. Tenants in common own undivided interest in the property, meaning they own a percentage of the entire property. So, for example, a tenant in common holding a 50% ownership in a house does not own the right half or the left half of the house, but rather 50% of the entire house. At death, a tenancy in common is passed along in a similar method to other property interests, whether through instructions of a will or according to intestate succession. Joint tenancy is a unique type of property ownership. Unlike tenancy in common, joint tenancy comes with an automatic right of survivorship, so that at the death of one joint tenant, the interests of the other joint tenants swell to include the deceased tenant's interests. So, for example, if three joint tenants own 33% of a property, upon the death of one joint tenant, the other joint tenant's interest will swell to 50% each, regardless of any instructions the deceased tenant may have left in his or her will. There are four distinct marks of joint tenancy known as the four unities. The unity of interest means that all joint tenants have an undivided share in the property that is jointly held. The unity of title means that the joint tenants acquire the property through the same transaction, inheritance, or other method of acquisition. The unity of time means that the joint tenants acquire ownership at the same point in time. One joint tenant cannot acquire ownership of the property after another joint tenant. The unity of possession means that each joint tenant individually has the right to possess the whole property. The modern presumption is that unless an intent to create a joint tenancy is clearly evident, such as through a conveyance that explicitly states, as joint tenants and not as tenants in common with right of survivorship, a tenancy in common is formed. Finally, a joint tenant may dispose of his or her interest in the property, but doing so will destroy the joint tenancy, replacing it with a tenancy in common. If there are more than two joint tenants, however, the remaining joint tenants will remain joint tenants with each other, while becoming tenants in common with a new co-tenant. The right to partition is a co-tenant's right to demand that the property be divided so that he or she may possess absolute sole ownership in a share of the property. If an arrangement cannot be worked out among the co-tenants on their own, the co-tenant desiring partition may petition the court. If the property cannot be equitably divided, such as is often the case with a residence, then the property will be sold and the proceeds divided. Both tenants in common and joint tenants have the right to partition. This is generally an absolute right, meaning that the other co-tenants cannot prevent a co-tenant from demanding partition of the property. This right can, however, be limited by contractual agreements between the co-tenants. Tenancy by the entirety is the last main form of property ownership. This is a special type of joint tenancy for married couples. It stems from the common law view that husband and wife are one entity. It requires the four unities of joint tenancy plus the additional unity of marriage. Similar to joint tenancy, tenancy by the entirety includes the right of survivorship. Unlike joint tenancy, however, tenants by the entirety generally lack the right to sever the tenancy, as husband and wife are considered one person. Therefore, terminating a tenancy by the entirety, whether by partition or conveyance, requires the consent of both parties. Many states have abolished tenancy by the entirety. Arkansas, however, continues to maintain it. So, if you have bought a house with your spouse in Arkansas, you probably own it as a tenant by the entirety. I hope that this has been helpful. I have included my firm's information here, so if you have any questions or comments, please feel free to contact me.